Trial preparation in New York starts months before you enter the courtroom. I'm Rachel Washington, trial attorney with 15 years of New York courtroom experience, and I'm going to show you how to prepare for trial the right way, because by the time you're standing before a judge, it's too late to fix your mistakes. The foundation of trial preparation is your note of issue and certificate of readiness. Under CPLR 3402, you cannot get a trial date without filing these documents, and filing them prematurely can hurt your case. The certificate of readiness is your sworn statement that the case is ready for trial, that discovery is complete, all parties are joined, and there are no outstanding motions. Here's what trips up many lawyers. You cannot conduct discovery after filing your note of issue without court permission. File too early, and you're stuck without the evidence you need. File too late and you delay your trial date, sometimes by months or years depending on the court's calendar. My practice tip, have a discovery completion checklist. Have you deposed all key witnesses? Have you obtained all necessary documents? Have you retained and prepared your experts? Only file your note of issue when you can honestly certify the case is ready. Once your note of issue is filed, you'll be assigned to a trial part and given a compliance conference date. This conference is crucial. It's where trial dates are set and pretrial issues are resolved. Come prepared with realistic time estimates and any scheduling conflicts documented. Now let's talk about jury selection, because New York practice differs significantly from federal court. In state court, the judge typically conducts voir dire, not the lawyers. You submit proposed questions, but the judge controls the process. Prepare your jury questionnaire carefully. Focus on bias that affects your specific case. Personal injury cases need questions about medical experience and insurance work. Contract disputes need questions about business ownership. Don't submit generic questions. Tailor them to your case theory. During voir dire, pay attention to body language and tone, not just answers. Jurors often say what they think the judge wants to hear. Look for hesitation, defensiveness, or overly eager responses. These tell you more than the words themselves. For challenges, you get unlimited challenges for cause if you can show actual bias. Peremptory challenges are limited, typically 6 per side in Supreme Court cases. Use them strategically, not just because you have a gut feeling about someone. Evidence preparation requires understanding New York's evidence rules, which closely follow the federal rules but have important differences. Business records exceptions under CPLR 4518 are broader than federal equivalents. Hearsay rules have New York-specific applications you need to master. Expert witness disclosure follows CPLR 3101D. You must disclose the subject matter of your expert's testimony and the substance of their opinion. This isn't as detailed as federal practice, but it's enough to prevent surprise testimony at trial. Here's my trial preparation system. Create 3 timelines. First, a chronological timeline of the facts. Second, a legal timeline showing when causes of action accrued and statutes of limitations ran. Third, a discovery timeline showing what evidence supports each element of your claims or defenses. Document organization is critical. I use trial notebooks with sections for opening statement, witness outlines, exhibit lists, jury instructions, and closing argument notes. Each witness gets their own section with deposition excerpts, document references, and examination outlines. Settlement conferences are mandatory in most New York courts before trial. Don't treat these as formalities. Prepare settlement statements that tell your story persuasively. Include damages calculations, key evidence summaries, and realistic settlement ranges. Judges appreciate lawyers who come to settlement conferences prepared to negotiate seriously. Bring decision makers with authority to settle. Have your client present or immediately available by phone. For trial scheduling, understand that New York courts operate differently than federal courts. Trial calendars are often crowded and adjournments are common. Build flexibility into your schedule and your client's expectations. The week before trial, conduct witness preparation sessions. Review testimony, practice difficult questions, and discuss courtroom procedures. Don't coach witnesses on what to say. Prepare them for how to say it clearly and credibly. Final trial preparation includes exhibit preparation with pre-marked exhibit stickers, witness subpoenas served properly in advance, and opening statement practice. I rehearse opening statements out loud multiple times because what sounds good in your head often doesn't work in the courtroom. Day of trial logistics matter. Arrive early to check technology, organize your materials, and meet with your client. First impressions start when you walk into the courthouse, not when trial begins. My final advice, prepare for trial as if you're definitely going to trial, but remain open to settlement until the jury is sworn. Most cases settle, but the ones that don't require thorough preparation to succeed. Professor Mitchell will now explain what happens when your trial ends, whether in victory or defeat.